Hey listeners, welcome back to We Dissent. This is Liz Cavell.
And I'm Rebecca Markert.
And this is a little bonus episode just to update you all on the decision that came down in a case that we discussed way back in our first episode. It'll just be Rebecca and I today. We are without Allison and Monica, and that's just so that we could get something up as quickly as we could to update you on some of these case outcomes. So, Carson versus Makin was the case that we talked about in episode 1. And if you recall, this was a case that came out of the state of Maine that had to do with Maine's system for providing public school secondary education to students that reside in districts that don't have enough kids to operate their own secondary public school. And if you remember, the way that Maine did this in some school districts was to pay tuition to the school of a family's choice to absorb their student. And the criteria for which schools could participate and receive that funding excluded sectarian schools. So Maine did not want to give direct public funding for public school education to sectarian religious schools, in keeping with the Establishment Clause and their anti-establishment interests. But there were two families that wanted to send their students to really Christian schools in Maine, and those schools directly conflicted with the criteria set forth by Maine. So they sued. This made its way up to the Supreme Court after lower courts found in Maine's favor. And so obviously that was a bad sign. And this is, of course, a ultra-conservative Christian plaintiff, which you've heard us talk about, have become favored plaintiffs for this Supreme Court.
And if you recall from that first episode, the title of that episode was actually The Sleeper Case, Carson v. Makin. And I find it interesting because it remained the sleeper case throughout this term. The decision in this case was handed down on a Tuesday after the federal holiday for Juneteenth. We were digesting that information, and by Friday, the court had handed down its decision in the Dobbs versus Jackson case, which, of course, overturned Roe v. Wade. And so that became the news of the week, and Carson kind of got left behind again. It was kind of this huge decision that upended decades of precedent, again under everybody's radar. I thought that was interesting that it remained the sleeper case throughout. But the court did decide 6-3 in an opinion by Chief Justice John Roberts that when states and local governments choose to subsidize private schools, they must allow families to use those taxpayer funds to pay for religious education.
You will be forgiven if you do not remember anything from episode 1, and also you didn't notice all these hellacious, upending decisions that happened the same week as Dobbs and Bruin and all the other disasters of decisions. But we did discuss in our episode 1 what our own predictions were for Carson. And I think that we pretty much predicted that this would come down along party lines, 6-3, that you'd get an ultra-conservative majority finding for the families, and that we would see some concurrences that were really strong in favor of basically how bad the discrimination interest is here when public funding is not going to only, ultra-sectarian schools. And that's pretty much exactly what we saw.
One of the things that I think is also interesting from this case, Chief Justice Roberts is the one who wrote the opinion. He's also the justice who wrote the majority opinions in the Trinity Lutheran case, which involved funding in the state of Missouri, where they were funding secular projects like resurfacing playgrounds. And Trinity Lutheran operated a preschool and wanted to use those funds to resurface its playground, but of course it's a religious organization. And in that opinion, Roberts wrote that the state of Missouri, if they were doing if they were giving out these funds, they also had to allow religious organizations to participate in that program. That decision was 7-2, sort of a shocking decision from 2017. Then 3 years later, we had the case Espinoza versus the Department of Revenue in Montana. And Roberts, again, wrote that decision. In the Espinoza decision, the court rules in favor of the Christian plaintiffs in that case and says that if the state of Montana is going to provide funding, it cannot exclude religious organizations. In fact, it's discrimination if you do that. So in those cases, they kind of mentioned or kind of inferred that there is a distinction between the status of the organization, whether the organization is a religious organization or a secular organization, versus the use of those funds. If the funds presumably were going to fund religious activities or worship, it was understood in 2020 that the state could not give out that money for that type of activity. Obviously, the constitutional principles that we're all aware of is that we do not fund religious activities. We do not allow our taxpayers to fund religious activities. So John Roberts writes that opinion, rules in favor of the plaintiffs there, but seems to maintain this status versus use distinction. Fast forward to this year, 2022, and he writes again this decision in Carson, and he says everything that I said about status versus use, that's not practical, which is something that we said way back then, that you can't really make a distinction between status and use, especially when you're talking about money. But he says that there's really no distinction between the two. And if the state is going to provide funding for whatever purpose, here, religious education, then they cannot exclude religious organizations or churches even when they are planning to use that funding for religious activities, instruction, or worship. And even if they are schools or institutions that discriminate.
We talked about this in episode 1 when we were sort of doing our predictions on what they could do in this Carson decision. We talked about whether or how they would preserve what the Establishment Clause still allows states to do in terms of not giving funding to religious actors. And in this decision, they didn't really leave that much daylight there. It again, and the dissent pointed this out, it was this just kind of new perversion of the First Amendment where the free exercise clause and the government not discriminating against religion or Christianity became the primary focus of the analysis. And the Establishment Clause interests are just ever shrinking and shrinking to the point where the court really doesn't care that much about Maine's interest in not forcing its taxpayers to pay for religious education. That would be the Establishment Clause interest. So, and we can talk about the dissents too, because again, these were some powerful dissents, like many this term, 2 separate dissents. In this case, one was written by Justice Breyer and the other was written by Justice Sotomayor. I'll start with Breyer's dissent, and he really gave some kind of powerful pushback on the idea I was just talking about, which is that the First Amendment has both the Establishment Clause and the Free Exercise Clause, and that they are supposed to and have for decades been recognized by the Supreme Court as working together, and that courts should always be sort of recognizing the play in the joints between the two clauses. And play in the joints has been a phrase used by the court for decades to describe how the analysis has to balance the interests that exist in the Establishment Clause against the interests of individuals in the Free Exercise Clause. And the case here just pretty much does away with the Establishment Clause interests and only focuses on the free exercise interests. And the majority here saying that states must give funding to religious schools if they fund public schools or non-secular private schools in the same scheme is just another lurch to the conservative. It's a big difference saying states must fund religious schools and states may, compatible with the Establishment Clause, give funding to religious schools. One other point that Breyer was raising is that this goes way beyond Trinity Lutheran. Like Rebecca was saying, just a few years ago, this court decided Trinity Lutheran, and a couple years later decided the Espinoza versus Montana case. And Breyer's pointing out that this is different than what happened in Trinity Lutheran. So he's basically trying to salvage something of the status use distinction, right? In Trinity Lutheran, schools were excluded from the funding, and he voted in the majority in that case simply because and only because they were owned, controlled, affiliated with a religious organization. It was a preschool or a daycare type of entity that was affiliated with a church. But here, Maine was choosing not to give funds to schools whose whole entire existence is the indoctrination of kids in every subject through a religious lens. So he was pointing out that this goes way further than Trinity Lutheran and what the court has done before. And the same with Espinoza. This goes way beyond Espinoza for the same reason. There is a difference between programs that, in his view, funding programs that exclude religious actors simply because they have religious affiliation versus states refusing to give funds where the funds will be used to promote religion, teach religion, and advance religious views.
And to his credit, yes, he moved from the majority in Trinity Lutheran to the dissent in Espinoza because he did want to maintain this sort of semblance of status versus use distinction. And even after Espinoza came down, I think a lot of our organizations were like, that's not really practical. For years, we've all been saying that just giving funds to a religious institution, even if you do that for a secular purpose of resurfacing a playground or, redoing a bathroom or something like that, obviously frees up funds within their budget for those really religious purposes so that they can have, better music or better Bibles in their pews or something like that. Money's fungible like that, and you can't really determine what they're using it for. And so the status versus use distinction, at least in my view, was always sort of one that I think was just a weird parameter that courts sometimes use and was never going to be helpful and obviously lead to more litigation down the line. But obviously in this case, Carson, John Roberts just blows that distinction out of the water, and it doesn't matter. If you're providing a funding program that is going to be generally available to organizations or individuals, then you cannot exclude religious organizations. To do so is discrimination against religion. But what Liz was talking about earlier, Justice Breyer was talking about this play in the joints idea that these clauses work together. And here's a quote from his dissent that kind of explains that a little bit. He said, "In my view, Maine's non-sectarian requirement falls squarely within the scope of that constitutional leeway." He also is a justice that's big on neutrality. He believes that the government should be neutral towards religion. We saw that come up in many other cases, including the Ten Commandments cases that he wrote back in 2005. But here's another quote from his dissent that talks about just the importance of the government being neutral and what the Constitution says about that. He writes, "The religion clauses thus created a compromise in the form of religious freedom. They aspired to create a benevolent neutrality, one which would permit religious exercise to exist without sponsorship and without interference. The basic purpose of these provisions was to ensure that no religion be sponsored or favored, none commanded, and none inhibited. This religious freedom, in effect, meant that people were entitled to worship God in their own way and to teach their children in that way. We have historically interpreted the religion clauses with these basic principles in mind."
Right. And I just want to also say to Rebecca's point a few minutes ago about how obviously untenable the court's kind of project to distinguish between status and use and insist on government funding going to religious organizations when it's just a status-based distinction. We have Justice Sotomayor's dissent. And Justice Sotomayor basically agrees with Justice Breyer on his points in dissent, but she writes separately to basically say, I told y'all this was going to happen. Justice Breyer, you were in the majority on all of those other cases. And basically, I'm writing to say this court never should have started down this path, like from Trinity Lutheran on. And she dissented in Trinity Lutheran way back and all along the road. She always believed that the government action in refusing funding in those other cases was perfectly appropriate under the First Amendment and both clauses, the leeway between the clauses that Breyer was just referring to in the quote that Rebecca gave. So she agrees with Justice Breyer that Trinity Lutheran and Espinosa are distinguishable from what Maine was doing in this case because, again, pointing out that it's really significant that Maine is trying not to fund actual religious education. Like these conservative schools that you might remember Rebecca describing in episode 1, the conservative Christian ideology flows through every single part of the education at these schools. It's not just that they are religious schools or parochial or that they teach religion. It's that they approach the students' education in every way, in every subject, through a lens of evangelical Christianity. And that is different than what was sort of sanctioned in Trinity Lutheran and Espinosa.
We should probably talk here about one of the most concerning things about this majority opinion is that a state's anti-establishment interest, this interest to keep church and state separate, is not one that is a compelling interest that would survive constitutional review.
The court's basically saying to the states, you can't prioritize a greater anti-establishment interest than what we say the federal constitution requires. Maine is also saying, hey, we have a state constitution, and it also embodies these anti-establishment of religion values and principles. And that's our state interest. We think that's compelling. And the court is saying, well, when it comes to someone saying, but my free exercise right, your interpretation of what your establishment clause requires can't exceed what we say the establishment clause requires on the federal level. And oh, by the way, what we think the establishment clause requires is barely anything. It's just a complete departure. And Justice Sotomayor's dissent really, I think, recognizes the alarming nature of what's going on in this case. Again, a sleeper case that, unfortunately, because it's one of many, isn't getting a ton of attention, but it is a real shrinking, even more to the point of being almost nothing, the separation of church and state, and even just a state's ability, individual state's ability to protect the separation of church and state. And I think her best quotes is that last line of her dissent, which is Justice Sotomayor saying, today, the court leads us to a place where separation of church and state becomes a constitutional violation. If a state cannot offer subsidies to its citizens without being required to fund religious exercise, any state that values its historic anti-establishment interests more than this court does will have to curtail the support it offers to its citizens. With growing concern for where this court will lead us next, I respectfully dissent.
And if you follow our Facebook and Twitter pages, I took that quote and we made it into a graphic because it was such an amazing quote. The morning that the decision came down and we're all racing to read through the opinion and put out our statements, our team, of course, rightly so, was focused on Breyer's dissent because it was longer and had a lot in it. And I kept saying, let's not forget Sonia Sotomayor because she was amazing in her very short dissent. I think it was only 5 pages long. It wasn't very long at all. But that line, and she just called it out straight. She said, this court continues to dismantle the wall of separation between church and state that the framers fought to build. And of course, as we go on in the term and see other cases come down, it gets worse.
Yeah, and those quotes basically sum up really an honest reflection of what the court did in this case. It's basically that quote that I read. States can't offer public funding without offering the same funding to religious exercise, not just religious organizations, but the exercise of religion. And it doesn't matter if the state feels more strongly about the separation of church and state than the United States Supreme Court. And that's not the way it's supposed to be.
And we are lawyers, obviously, and whenever we look at these cases, we try to determine how narrow is the decision. I mean, what is going to be the greater impact of this decision? Everybody has been asking, well, Maine is a pretty unique situation. There are not a lot of states. In fact, there's only 2 other states like Maine that have this system where they don't provide public schools for secondary education in rural areas and have a funding scheme so that parents can send their kids to a secondary school. I think it's Vermont and New Hampshire. So when you're looking at it, you're thinking, well, it's not going to have a lot of impact because there's only 3 states in the whole country that have this type of scheme. But really, it does have broad impact because obviously there are many different types of voucher programs across the country. The court really is saying that not only may states devise these types of programs, but when they do, they must have religious organizations participate. So taxpayers now are really, for the first time ever, compelled to fund religious education. This is something that our founding fathers would not have agreed with at all. And in fact, Thomas Jefferson wrote that it would be sinful and tyrannical to do so, to compel one of our citizens to fund religion for religious services or worship that would be equivalent basically to a government-compelled tithing.
Right. I'm pretty sure also in context, Jefferson was talking specifically about taxpayers being taxed to fund religious education. That was something that our founders specifically detested, and that was part of what was being embodied in our First Amendment was a guarantee against that type of government sponsorship of religion. But, not much made of the historical and the tradition of anti-establishment in our nation. It's weird.
Well, and I mean, just that he phrased it the way that he did, sinful and tyrannical, those are very strong terms to be using. And I feel like we can't really be like, he didn't really mean it like that. I feel like he was pretty strong in his opinion that we should not be making our citizens pay for religious education. The other thing that I've been asked in this last week is, so me as a taxpayer, am I now being forced to pay for a religion that I don't believe in? And the answer to that really is, well, if you live in a state with some of these voucher programs, yes.
Yeah, you probably are.
You probably are. But it also, even if you live in a state that doesn't have this type of program for religious education, states are now incentivized to devise those types of schemes. And once they do, then yes, that money must go to religious organizations as well. So it could be happening to you even if you deem that you're living in a safe state right now.
And it's not just religious education, religious schools. Like this court is requiring this type of government sponsorship across the board. I mean, look at Fulton. Sotomayor is not exaggerating here. This is common. Like government money goes to nonprofits. It goes to charities. It goes to different organizations that do community work. And more, you're seeing courts saying those government entities must give that money to religious organizations that might be doing the same community work, but they're doing it in a totally discriminatory way that most taxpayers would not agree with or agree to fund.
And one of the things that a lot of people are saying too is that, well, okay, so if we have to make this funding available to all organizations, secular or not, that's okay because we can put all these restrictions on the funding. So if you're going to accept this funding, you then also have to meet these certain conditions, like your teachers have to be licensed. You have to abide by non-discrimination rules that we've devised and things like that. In my opinion, that's the next level of litigation here, because we have seen religious organizations say we want the money, but we also don't want to have to follow any of the rules that you guys are setting out. I mean, we still want to be able to discriminate. We still want to be able to do our thing. But yes, you have to give us money. And if you don't, you're discriminating against us. But we also still get to discriminate in hiring LGBT teachers or expelling students who, display non-gender conforming behavior, that type of thing.
Right. And I mean, those kind of factual parameters existed in this case, but the court didn't have to really make any decisions about what Rebecca's talking about. But I agree 100%, Rebecca. That is the next frontier. There's always a next frontier. Like, there's never an end to what religious groups are going to demand in terms of privilege and special treatment. And when it comes to funding that is curtailed by anti-discrimination rules or educational standards, things like that, as quick as a state can move to do that, you can bet there's going to be litigation saying, like, no, now you're discriminating against us based on our sincerely held religious belief that gay people are evil and going to hell. And you can't do that. We don't want that accountability, but we still get the funding. It's just the have your cake and eat it too legal argument that wins the day again and again at this court.
And we bring up LGBTQ issues all of the time, but as Liz just mentioned, it also will affect educational standards. So yes, they're going to say, no, it's my sincerely held religious belief that the earth is flat, and I'm not going to teach science in the manner that you, state of Maine, state of California, or whatever state it is, want me to teach science, because that's not what I believe. And that is, your money's going towards that too.
Yeah. There's definitely no end to where this type of constitutional analysis, you can't see my scare quotes, but leads. It's this ever expanding view of what free exercise requires. There's really no end to what we all end up funding in the long run.
And I want to be clear too. I'm not saying that states shouldn't try that and shouldn't pass those laws and shouldn't attach certain conditions to the funding. I do think that when those schemes come up where the government is providing funding and there are certain conditions attached to that funding, I do think that there are going to be religious organizations and schools that look at that and say, yes, we're going to abide by all of that because we want the money. But there are going to be other organizations like Bangor Christian in Maine and Temple Academy in Maine where they're not going to want to abide by those rules and regulations, and they will sue. That remains to be seen how that's all going to play out. But I do think, at this point, states should try to pass those types of law. They have to, yes.
Taxpayers don't want to pay for discriminatory schools, and especially in places where states are trying to fulfill their obligation to provide public school education. We're trying to give kids that live in districts with no school. Of course, we don't want it to go to schools that discriminate. And actually, in actual school at issue in that case, I can't remember if it was Bangor or the other one, Temple, but one of them did not take funds from the state of Maine, even in the run-up to this litigation, because they didn't want to be bound by state regulation or whatever strings would come attached to that government funding. So, that school itself is probably emboldened to be like, oh, cool, we won, we get the money, and we get to keep doing what we want. And then it'll have to go back to square one to see what states will do in that situation, and then, of course, be sued, and then we're off again.
So another talking point that the other side has been putting out there, particularly a lot this past week, is taxpayer funds already go to different religious schools, particularly when you look at higher education. We have religious colleges and universities that receive federal funding, and college students who are looking for financial assistance. They're able to get student loans, particularly Pell Grants, and they can take those funds and go to religious colleges and universities, which same situation, they're going to be having religious classes and religious instruction, and some of that religion may permeate every single class that that student takes. So how's that different, Liz?
So, I mean, first of all, there's so many different ways that funding flows to schools. Like you mentioned, FAFSA, where students themselves apply for funding and use it at the school of their choice. And then there's like Title IX funding, and there's, all this different types of federal funding that flows to universities, both private and public. But my understanding of much of that funding is that we're in territory where those schools are agreeing to abide by anti-discrimination laws that are set by the federal government. Like at the university level, we haven't seen this push by religious schools, religious affiliated schools, to be able to take federal funding, yet not comply with any federal requirements that are attached to that funding. And there are schools that are like uber Bible colleges that just absolutely will not do any of those things, but they don't take federal funding. Like that's pretty much the deal. It's not that hard to understand.
When you're talking about those uber religious colleges, it just brought to mind my favorite show is Gilmore Girls. And one of the characters in Gilmore Girls is Lane. And she is a Korean American, and her mom's very strict and very religious. And so when she's applying to colleges, she gets all of these Seventh-day Adventist college applications. She sits down and she's going through them, and she's like, there's one school that has a park for boys and a park for girls. She's like, my life is over.
Right, exactly. Not a school for federal funding.
Right.
No, exactly. And I mean, it is not correct to say that that is evidence of that Carson is just reflecting the status quo, because that is not what is happening when universities accept federal funding.
What about the age of the students, too? I mean, we're looking at adults versus young and impressionable children. I mean, at the schools in the state of Maine, in the 5th grade, they're asking their students to proclaim Jesus and to refute the teachings of Islam. We see with a lot of these religious proselytizing teachers and people on the streets and things like that, I mean, they really are targeting students of a certain age because they really do kind of want to get them when they're young.
Right, 100%. And I mean, when we're talking about K through 12 education, like that is where we, as a society, we have accepted this like societal responsibility to provide free K through 12 education to all of our kids. And there's just something different about that when it comes to what we are and aren't funding, because your money is going to go somewhere to educate these students. And the thumb or the fist is being placed on the scale to move so much of that taxpayer money into these private religious schools where most taxpayers don't want it to go. And also, of course, we talked about this in the Carson episode. It also is this concurrent project to really undermine our public secular schools. Public education also lost the day in the Carson decision. So that is the update on Carson versus Makin. Thanks for listening. We will have some other updates in the feed for some of the other decisions that have come down since we recorded our episodes on them. So stay tuned for those.
I'm Rebecca Markert.
And I'm Liz Cavell.
Thanks for listening. We Dissent is a joint production of the Freedom from Religion Foundation, American Atheists, and the American Humanist Association. It is hosted by attorneys Liz Cavell, Allison Gill, Monica Miller, and me, Rebecca Markert. Special thanks to FFRF law student intern Katie Sticklin, who assisted with producing this episode. Other production support comes from James Fediplace and Greta Martins. Audio engineering provided by Audio for the Arts, based in Madison, Wisconsin. Thanks for listening.